Hey everyone, Chip Kosei here with the latest edition of Laws for Life. Don't know if you can hear that in the background, but we are at sunny Algiers Point today. I don't know if you can hear the beautiful music coming from the Natchez. You might want to give it a second and have a listen. Not exactly hip-hop or smooth R&B or classic rock, but in New Orleans that's some pretty sweet music. Anyway, today I want to talk to you about what we call in Louisiana is prescription. Lots of you might have heard it in terms of a statute of limitations. It's how long you have to file a legal document to protect your rights so that you don't lose them. In Louisiana, of course, we do everything differently here, right? We have civil law versus common law like they have in England or any other state in the United States, but here we call it prescription. Some of the prescription periods that I think are important to know about are, first of all, if you are injured, like in a personal injury action, a car accident or whatever, you have one date from the time that occurrence happened to file. Now, when you file a lawsuit, it has to be in a court of what we call competent jurisdiction and proper venue, meaning you have to file in the proper courthouse and in the proper location. If you don't, then you're likely going to get tossed out on a technicality. There are some exceptions to that, and that is if you don't know about something until after a year because you couldn't have known about it with any sort of due diligence, then it's a year from the time of knowledge. Now, there's also an exception to that. If you have a medical malpractice action, it's a year from the date of knowledge, but there's also another concept which plays into this, which is called preemption. So if you learn about it and you do something about it within a year of finding out, you're fine as long as it's not a total of 3 years or more from the date of the occurrence. If it's more than 3 years, but within the year that you find out, it is too late and you can't do anything about it. Now, a lot of us have property in the city, whether it is our family home or whether it's rental property or something like that. I want to talk to you about something called acquisitive prescription. We see this a lot in the law, and that is, let me give you a scenario. Let's say your neighbor puts a fence up and it's in your yard, say by 2 feet, and you don't do anything about it. And let's say that fence has been there for 30 years. If you don't do anything to get that fence out of the way and interrupt that encroachment on your property, then your neighbor can actually acquire and own that portion of your property. And it can be disastrous because if you go to sell your home, it will cause the surveys to be off, there will be a cloud over the title, and you may not even be able to sell that property. So always knowing the time limits are very important. Lastly, and going back to a personal injury example, if you have a case where, let's say, the person that hurt you, they didn't have enough coverage to cover your losses and you have to use your own uninsured motorist coverage, then the prescription on that is 2 years. So just wanted to give you some of the things we see most often to protect you. I sure hope this video helps, and we'll talk again soon. If you have any questions, please email me, chip@kosselaw.com, that's COSSELAW.com, or even you can call me at the office, 588-9500. We'll talk again soon. Thanks a lot.